ready to proceed?
Yes, sir.
All right, you may bring the jury.
Jury's all present, Your Honor.
Okay, very good. Welcome back. Ladies and gentlemen, you have heard all of the testimony, received all of the evidence. It's now time for closing arguments. You give the first your attention to the state.
Thank you, Your Honor.
Yes.
And please report.
Yes.
Okay, so finally, after all these weeks, I get to talk to you again directly. And the way this works is because the state, I have the burden of proof. The first thing that happens is I talk to you about the law. Not going into facts, not arguing to you about our position on it, just talking to you about the law. I did that a little bit in an opening statement. I'm going to talk to you a little bit more about that, and Mr. Savage will get up and he'll do his closing argument. After that, then I'll get up and tell you about our view of the facts in this case. So let's start from the beginning. Why are we here? What are the charges? The charge that the defendant is indicted for is murder. And as I told you in opening, the definition of murder is the unlawful killing of another person with malice aforethought. And note again that the word premeditation, as you're used to hearing it probably in your daily life, is not included as an element. We do have malice aforethought. I'll get to that in a minute. But we don't have this notion of premeditation that lasts for days and weeks, months, this grand scheme, a grand plan. That is not required under South Carolina law. What is required is malice, which is not a character trait. It's a feeling. It's an emotion. It is a thought that occurs in time, which gives us the, when I say in time, I mean the aforethought part, not an afterthought. Malice has to be in the mind before the shots are fired. It can be meanness. It can be ill will. It can be hatefulness. It can be just extreme and reckless indifference to human life, like 8 shots to the back. Those can be indicia of malice. And again, forethought is just not something that occurs later. It has to be present. The malice has to be present when the shots are fired. It can arise in an instant, but as long as it's there when the fatal shots are fired, the state has proven malice aforethought. Now, on the other side of that, the judge will tell you that you have the option of voluntary manslaughter. And this again hinges on that malice and heat of passion. And I taught you a little bit about that in opening. Voluntary manslaughter is an unlawful killing in the heat of passion upon sufficient legal provocation. Heat of passion, legal provocation. What does that mean? Heat of passion. That means something that happens quickly before a normal person would have time to coolly reflect and think hard about what they're doing. And as I told you in opening, what I call it sometimes is a killing under the influence. And when I say that, I don't mean under the influence of alcohol or drugs or anything like that. I mean under the influence of emotion. And what you, as jurors in this case, have to decide is that heat of passion, malice, difference. because from a distance, they could look the same. You are the ones that get to decide that. The facts are yours. Provocation must be overt, a threatening act, a physical encounter. Words are never enough. It doesn't matter how mean somebody talks to you, what they call you, F the police, whatever, words alone are enough. It has to be accompanied with a threatening act or some sort of physical encounter for there to be sufficient legal provocation. We have to have those things at the same time, heat of passion and legal provocation together at the time of the action. Now, these things do not have to dethrone all reason. They don't have to shut out all knowledge or volition. We aren't talking about some sort of insanity defense. What we're talking about is the effect of the heat of passion, anger, emotions like that, after being provoked. These things, the heat of passion and the provocation, have to be of the type. We are talking about things that happen in everyday life, like somebody cutting you off in traffic. That's not enough. Even if someone's committed a traffic violation, that doesn't provide the sort of heat of passion and provocation that an ordinary person would be driven to do violence. It has to be the kind that would naturally disturb the sway of reason and render the mind of an ordinary person incapable of cooling off. Those are the principles of voluntary manslaughter. As you have seen, like I talked to you in the opening statement, provocation is not the same as justification. Just because someone was provoked doesn't mean that it gives them license to do whatever they want, whenever they want. Provocation does not mean justification. And mitigation, making something less offensive, doesn't excuse it entirely. Mitigation is the type of thing in the law that tugs at your heartstrings. Mitigation is the type of thing that makes you say to yourself, no, I know somebody shouldn't have done that, but I understand why they did it. I know it was wrong, shouldn't have done it, but I get it, I understand it. That's mitigation. That goes to sentencing, which is not your issue. It's not your issue. This is not a death penalty case. You do not have to concern yourself with that. Self-defense is another concept that the judge will tell you about, that you've heard about through this trial. There are elements of self-defense in order for it to apply in a case. The defendant must be without fault. Without fault and bringing about the difficulty. The defendant must be in imminent danger. The defendant must have no other way out to avoid danger. If any one of those fails, if we've disproved any one of those things, self-defense fails. Imminent, immediate, no other way out. Think about those things when you're thinking about the testimony and the evidence that you've seen and heard. You will hear an instruction about reasonable force, what officers are supposed to do and are allowed to do when effecting an arrest. Again, you have to look at all of the circumstances, all the weeks of evidence that you've heard, all of the exhibits that you've seen, and see what it appeared to the officer at the time he used deadly force. And then, once again, those words come back. Would an ordinary, reasonable person, knowing everything that he knew, find that it was necessary to use deadly force? Reasonable and necessary. Reasonable person with knowledge that there is no taser cartridge, knowledge that there's 18 feet, knowledge that there's 40 feet. What would a reasonable person think with those facts? what would a reasonable person think was necessary? And what we have to do, and you've heard this all your lives probably, is we as a state are charged with proving you these charges beyond a reasonable doubt. Be very careful with that, because there are a lot of things that beyond a reasonable doubt does not mean. The judge will give you an instruction, and you'll see that it's the kind of doubt that causes you to hesitate to act. Now, that doesn't mean that you don't deliberate, that y'all don't talk, and that y'all don't figure out your verdict. It means that when a reasonable person, a reasonable juror is looking at the evidence, would that person hesitate to rely on all that proof? Would it cause them to hesitate to rely on all that proof? It means that it's proof beyond a reasonable doubt when we have proven our case, not beyond every doubt, not beyond the shadow of a doubt, but a reasonable doubt. And the reason why the word reason is used is because in life, it's almost impossible to prove things beyond all doubt 100%. Because 100% means that you're a party to the situation and you saw it for yourself. You're having to take other words for it. You're having to take evidence for it because you are jurors who were not there. In a nutshell, the way to look at reasonable doubt is this. It is proof that leaves you firmly convinced of the defendant's guilt. Firmly convinced, confident in the proof, and confident in your verdict. And when you look at all the evidence, and when you consider all of it, I submit to you, you'll be confident that the defendant's guilty. I'm about to sit down, and Mr. Savage is going to get up and talk to you about the facts. Before I do that, I want to talk about one thing that I think he and I are going to agree on, and that's all of you. I want to take you back to almost a month now. And a month ago, when we were in this courtroom and calling y'all up, y'all saw other people come up. You saw me strike. You saw Mr. Savage strike. And at various times throughout, you may have heard the clerk say, Mr. Savage, you got so many strikes out of 10. Madam Solicitor, you have so many strikes out of 5. Never did you hear clerk tell us that we used all our strikes. And what that means is we could have tried to keep any one of you on. We didn't do that. Neither side did that because we trusted you, because we had confidence in you. And everything that we've seen so far in you shows us that we were right. And I'm saying this now, I'm not trying to butter you up, because he's going to say the same thing when he stands up, but it's true. Y'all have been remarkably alert. Y'all have been remarkably attentive. And we know that we made the right decision in you. We know that you can do this. You can get it right. And I just ask you the same thing I ask of myself before I get involved in these things. And that's that you be strong, you be courageous, and you do the work. Do the work.
Please, the court, thank you. Foreign and ladies and gentlemen, the jury is so nice after a long time. Solicitor said a month. Scarlett, we finally agreed on something. And that is to thank you, each and every one of you, for being here, because your service is you've done it, so you know. The jury service is often looked at as a burden. And in some sense, it is a burden. You know, you've been taken away from families, you've been taken away from businesses, you've been taken away from all the everyday problems in life that you still have to accommodate even after your jury service. So thank you for being here. It's so important for those of us that are in this courthouse a lot. This is how our system works. You know, Scarlett has a view of the situation. I have a separate view. We can't agree, get it resolved. We put that burden in your hands. And as Scarlett said, in October, we received a questionnaire. And the purpose of that questionnaire was not to scare you with the sheriff coming to the door, but to get some information about you so we could learn about you, what your life's experiences have been, so that we could evaluate how we think you would do in terms of your life's experiences applied to the facts and controversy in this case. And as I told you on November 3rd, you're the top 2%. You're the one that both Scarlett and I agreed to, that of all the people that were here, the 600 people that were asked to come, we thought that you would be best suited. Pay attention, watch the testimony, listen to the testimony, to see what exhibits come in, and to evaluate that information, whether or not Michael Slager acted with criminal intent on April 4th, 2015. Not easy to do. Not easy to stand in judgment of a fellow citizen. But you have taken an oath, and that is your responsibility to do, and we accept that. You know, in the law, it's kind of interesting. The judge and I may disagree. Scarlett may disagree with the judge. And those disagreements can be resolved elsewhere. There are two courts in Columbia, not one but two. And if there's an issue with the judge and you think the judge made a mistake, we think that our position is more correct than what he has ruled. We go to Columbia. And we're entitled to do that. And we can have another judge, several judges, evaluate this judge. There's no place we can go to evaluate your decision. So whatever you decide on the facts of the case are the facts of the case, whether we disagree or not. Your facts are never questioned in the future. They don't go before an appellate court. They are what we find is a final decision. So in many ways, you have much more power than our trial judge. And in many ways, you have much more responsibility in exercising that authority. One of the questions that you were asked in the questionnaire, you may recall, what television station you watch, or you read the Postal Courier, or you read listen to NPR, that sort of thing. You know why we did that? It was to see whether or not you keep up with current events. Because in this case, for 18 months, the public has been barraged by information. Every one of you, I believe, every one of you, said in your questionnaire that you've heard about this and that you've seen the video. But my friends in the media showed a portion of it. And my friends in the media told a story to go with it. And the story went something like this. In North Charleston, South Carolina, a white policeman stopped a black motorist who had a brake light out. And the motorist ran away. And the policeman shot him in the back. And let me show you the video of what happened. That is the narrative those people sitting in the back 2 rows told you, told the public. It's true. Michael Slager is a white man. Mr. Scott is African American. Mr. Scott was driving a car with a broken cab. Mr. Scott got out of the car and ran and was shot. Well, that's true. But it's a false notion. Because what the media didn't do, and what I hope you have learned over the last 5 weeks, is that this shooting did not happen in a bank. Mr. Scott did not get shot because he had a broken cab. Mr. Scott was shot because of what he did on April 4th. For the media to tell you that he ran because of some family court bench warrant, you've heard the testimony. Scarlett told you on the first day of this trial that there's a debtor's prison. There is no such thing. Nobody goes to prison because they don't have money to pay the judge. Hardly anybody goes to prison. You've heard 9 times he was bench warranted. And you heard testimony on oath that the family court, the idea of family court is to protect the children in our community. It's not about prison. It's about providing for your responsibilities to your children. So that if somebody has a job and they have good intent, and they have good will, and they're good people, and they want to take care of their children, and they have a job, they continue right on with their job. And that's how the laws apply in this courthouse, in family court. Now, if you're repeatedly irresponsible, and you have a lot of money in your pocket, you don't take care of your children, there is the option to put people in jail on the weekend, so that they work during the week. They can provide that money to their children. So, under your oath, and in response to the questions proposed by this court, you said that you will forget all of what you heard before you came to the courthouse. You may not forget it, but that you will set it aside and make the decision based on the law and the facts as you give in this court. You know, that media propaganda for, well, as recently as this morning, continues. Because the media sees this case as not an individual case in North Charleston, not an individual case involving Mr. Scott, not an individual case of Michael Slager, who, by the way, you've heard his reputation. You've heard his colleagues, his supervisors, talk about his character, how he conducted himself, that he was a peaceful guy, that he didn't initiate problems, that he calmed problems down, that he was called upon on the midnight shift to go on the bar or whatever deal that was. And he was selected because of his personality. And you see him sitting in the courtroom. He's not a broke cop. He's not somebody with a history of abuse of power, abusing citizens. Not one citizen's complaint. In a guy that had to tase people and arrest people, and take felons into custody, give tickets, and no, there's not none. You haven't heard one word of disrespect that he gave the citizens or any citizens that ever complained about him. And that's part of the judgment you have to include when you evaluate this case. So, setting the false narrative aside, let's look at what the truth is in this case. And you can look at the truthfulness of this case by things you have seen and things that you haven't seen. For example, when we talk about his character, you heard testimony that he received a letter from somebody he arrested. You didn't read the letter, but you know he received a letter from someone he had arrested. And you know that he had a handwritten note from the chief of police. You didn't get to see it, you didn't get to read it, but you know that. And he got a letter from the solicitor's office about him that he didn't get to read, he didn't get to see. Like many other things you didn't get to see. And we'll go through that. Things that if we are really in truth searching for the truth, you can question in evaluating this case why you didn't get to see that. And you can't second guess the judge's ruling. You sure as heck ask why I don't have more information, if there's other information out there. And the person who asked is the state of South Carolina. Michael Slager has no obligation. If he didn't testify, if he didn't put up any information at all, the judge would tell you couldn't hold that against him. He didn't consider that in evaluating what he did on April 4th. But Michael Slager, as he did on April 4th, gave 4 statements of which you only heard a couple. And you can question why you weren't able to hear the other statements. Gave statements that anybody asked the questions of. And then the state law enforcement division questioned him 3 days later. He sat with them for hours, gave a statement. And because he did that, because he cooperated, because he gave the information to the best of his knowledge, what happens? He didn't tell me he kicked me, he didn't tell me he spit on me, he didn't tell me this, he didn't tell me he was on top of it. You ever been in a fight? Have you ever been in a situation where you're fighting? Somebody who's larger than you, somebody who's stronger than you, somebody who's violent in his behavior towards you, and then ask you, well, how many times did he touch you, or where did he touch you, how did he hit you? You can question why you didn't get information in this case. Why did the state law enforcement division testify about all the good work they did and not tell you about the evidence of Mr. Slager being tased? If that doesn't bother you, it should. Because this is a search for truth. And unless you're given all the information, all the facts that are available, it's hard to find. And that's the kind of information you deserve to have. Not just the media and their 16-second video of the shooting, but the media likes that because it's violence, it's racially inflammatory, it's the concept of whether it's in Baton Rouge, Louisiana, Milwaukee, Wisconsin, Staten Island, New York. This just becomes another example. Police misconduct. I hope you put an end to that. I hope you tell the state of South Carolina, you tell the media they have to do a better job. Because what happens when the media does this is they mislead the public, and the public then comes into court, and the people who are outside, the people who are threatening the community, they have a narrative of what happened. And because of what they've been told, they have certain expectations. And they expect that you'll just come in here and nod your head and not question their narrative. And give the judge an opportunity to put Mr. Slager in prison for a long time. But you were selected because of your courage, your willingness to look, to evaluate, and to stand up for the truth. So let's evaluate. Let's go back to 9:30 in the morning on April 4th, 2015. Officer Slager, North Charleston police officer with 6 years in the Coast Guard, perfect record, honorable discharge, has a desire to continue his public service. He signs up at that North Charleston Police Department. Goes through 9 weeks of training in Columbia. Goes through 9 weeks of field training in North Charleston. Goes through 4 years plus on the midnight shift in the violent neighborhood. Is successful, is commended by his superiors, and after trying for years, his wife gets pregnant, and he wants to switch the ship. So he goes from the South Bureau, midnight shift, under Sergeant Prosser, Sergeant Allen, we heard from him yesterday, and he goes to Central. You were out there, the Fremont Avenue is, Fremont Road, excuse me, is a sort of main thoroughfare, about a mile from the airport. As I looked, I'm now looking at this picture of Mr. Scott's vehicle, and I'm looking from east to west. And in front of the vehicle, Mr. Scott is taking off to the left, and that is Craig Road. Now, up to this moment, at 9:36:14 on April 4th, things were normal. Just because somebody can't find their driver's license, or they can't find their insurance card, or they can't do this, and they got kind of movement with their hands, and the passenger will look at you, that's not reasonable suspicion of criminal activity. There was nothing about this stop other than the brake light is out. And as you've heard from many of the officers up there, the brake light's out, the other person, hey, your brake light's out, you notice that, by the way, this is always on, you're right inside, 35 cents, and you're on your way. No ticket, no punishment, no fine, no points on your license, nothing. Oh, you can't find your insurance card? Well, you're supposed to carry your insurance card, is it in your glove box? No, do you want to look in your glove box? No, I don't want to look in your glove box. If he doesn't have an insurance card, which, remember, was found in his car, it's in evidence. If he didn't have it, write a ticket, come to court in 2 weeks, bring your insurance card with you, and it's all over. It's just not an issue. This is just a traffic stop for a brake light. Nothing to it. And at that point, as you see Mr. Scott running away, in the mind of Mr. Slager, as you know, there was nothing. But what had he done? Slager got on his computer, read the information in the driver's license. He never learned because Mr. Scott ran away. So he didn't have time to get feedback that the government, the FBI, put out a bulletin that Mr. Scott
Objection, Your Honor.
was armed and dangerous.
Objection sustained.
It's in evidence, Your Honor.
May proceed.
That information never got to Mr. Slager. While the state hasn't told you why you ran, you can ask that question and say, well, state, you didn't tell me why you ran. You knew why you ran. Why didn't you tell me? And instead of saying that he eventually, in our family court, he was going to deadest prison, there is no deadest prison. At that moment, Mr. Scott could have done the AutoZone, said, right, that way if he ran back another 10 yards the other way, he would have bought 35 cents by bowl on back business. But what did he do? Let's look at the time first. Because, you know, it's taken, how long we've been here? 5 weeks? You got that question maybe 2 months ago. It's taken 18 months for the state to decide what happened in seconds. In this case, it's not about even feet. It's about seconds and portions of seconds. So let's go through this time. At 9:36:14, I'm sitting in Slager's unit, and I see him running. It's a brake light. There's no reason to run. People don't run for brake lights. So as a trained law enforcement official, I get out of my car, as they say, I exit my car. He exited his car. He got out of his car, locked the door, and ran after him. And as he's running after him, he calls into dispatch. This is 223, his call number. I'm on the 1080 chase. Subject is wearing a green shirt, blue pants, and crates. He runs down a little bit more, but you know what? He didn't see it. So are we to pretend it didn't happen because there's no video of it? You know, there was a day before the media got on TV, when we had radios, and you couldn't see on the evening news the photograph. Does that mean World War I didn't happen? So, this idea about there's a video, the video ends here. And it doesn't pick up later until we have Mr. Santana's video. But it's almost as if they think nothing happened. Even though they have audio of what happened. So as he's running down Craig Street, Mr. Slager is following him, what does he do? Stop! Taser, taser, taser. We were out there this morning. It's on the yard. Turns the corner, loses sight of him for a moment. Fires his taser out. It's ineffective. What do you think? If a police officer stops you, I know it's frightening. Some people may want to run, for whatever reason. But if you're warned of a taser, isn't that about time to say, hands up, don't shoot? Doesn't happen. No complaints. The prongs of the taser zoom by him on the first shot. There's something wrong. No compliance. No thought of stopping. No thought of avoiding any confrontation. Think about it, the mindset of somebody wearing all this stuff, including OC spray, including a taser, including a gun, just to disrespect them. It's crazy. Who does that? Who attacks a policeman over a brake light? So this is not about a brake light. No. It's about the felonious conduct exercised by Mr. Scott, not Mr. Slager's decisions. It's the felonious conduct that Mr. Scott engaged in. matter of a decision that he made, whether he was on cocaine, alcohol, whatever it was. He made decisions to attack a police officer. Now, the impression that the media has, and the state is trying to sell you, is that nothing happened. He just ran after him and shot him in the back. Taser, 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 discharges the taser the first time. What's the time of that discharge of the taser? 36:32. So that would be the time is 9 o'clock in the morning. 36 is the minutes. 32 is the seconds. Seconds later. Does he stop? No. The primer zip by him. Does he stop? No. What does Slager do? Stop! Taser, taser, taser. How many seconds later was that? 13 seconds later. 5 of those seconds being tied up by the first taser. So it's 8 seconds later. Stop! Get on the ground. You can hear it. And by the way, I apologize for my poor choice of repeating what was said last night. I didn't mean it, and I apologize. But you'll hear the tape and you can listen to the F word. Third taser, what time is that? 6 seconds later. Think how quickly things will be, right? So the first shot doesn't take, the second shot he thinks takes, but he keeps resisting, he's trying to get up off the ground, he's in an aggressive mood, he's moving towards him. So Slager pulls the trigger again, because he makes the promise and he calms down. You know, if the taser was in him, he couldn't use the language. He couldn't shout back. He couldn't say what you can hear on that tape if he was being phased. So what happens then? It's not on video, so they're going to say it didn't happen. Well, you can hear what was going on the audio tape. It's not great, but you can hear what's going on. Get on the ground. Like, why would somebody say get on the ground? It's because there's resistance. There's not compliance with orders. How many times do you want to hear it? Get on the ground, get on the ground. This is not something that Slager was all ticked off that day or a malice in his heart. He was a police officer protecting us and the family. And he can't imagine why this guy of unusual strength, we didn't hear about that either. And perhaps martial arts strength, we didn't hear about that either, was fighting him. A guy who's got a gun, a guy who's got OCE, he's got all sorts of things, he's attacking him. And he knows he's got a radio. He's still attacking. So he knows he's going to call for help, and he's still attacking. Next stage. 37:02. Seconds. Drive, D-R-I-V-E, something different than I first heard. Using the taser, some of you may know about tasers. You can use your personal experience about tasers to determine how that works. I think the officer yesterday called it a ride. It sounds like a ride. It's quite a ride. No effect, none. Resistance continues. Compliance, no, it's not in the vocabulary. And you can hear the conversation. You may not be able to tell the words, but you can hear the voices, and you get a good idea of what was going on. Not on video, but it still happened. When's the next stage? Again, an attempt to drive something. Now what happens here, you've got to participate. You've got to get somebody here, 112, who understands computers, how they operate. Because I don't want you to rely on what I'm telling you. I want you to get on that computer when you get back and listen. So you can time what we have just gone through, the timing between the exiting the car, to the time to take the taser, to second taser, warnings, and get on the ground, the language that's employed there. And then you'll notice that there's a gap. 24 seconds. Much unlike the other gaps in the use of the taser. And you'll notice if you do your research in the jury room, that that is the time that Slager knows he's getting his butt cut, and he calls for help. Now what's interesting about that is he doesn't say, well, this is Officer Slager and I'm having a problem and send somebody down here. No, he calls, you saw that, right? That's his guy. They're the partners. That's who he is. Police officer who called it. So he calls specifically for Haversham. 156, it's Haversham's name. Step it up. No, he didn't say, I'm getting the devil beat out of me, and you know this, I hit me in the left eye, I just pinched my ear. No, he didn't say all those things that the solicitor wanted to leave the members. He said, yeah, here, give me some help. And how many officers have told him when they heard that call, they knew from the tone of his voice and the specific call of a specific officer, heroin funding, because they knew he was in trouble. But not too many people wanted to admit to all this. There was nobody out there. Some supervisors, somewhere along the line, I don't want to blame them because I know they got a tough job there. The Slagers all alone. By the way, you check the Sunday paper, all right? Promise me you'll check Sunday's paper. Well, it's read by the media, so you can question it and read it. But on Sunday's paper, you look to see if there's any crime reported on Saturday. You know, crime didn't say it's daylight savings time. I guess I'll get out early today. It doesn't work that way. Police officers will tell you you've heard from them every traffic stop, 24 hours a day, 7 days a week, blow up. And that's why in North Charleston the practice is when you're on the street, you say, I'm stopping a vehicle. They don't say who's driving the vehicle, or I mean, there's none of that stuff going on. They start moving in his direction just to be close to peace. And in zone 4, zone 5, and zone 6, nobody to come and be in the neighborhood when he makes this stop, and nobody in the neighborhood when he got in trouble. Because if there was a response time, that would be in accordance with the procedures out there. In a minute and a half, Haversham would have been there. He's told you. It's in the testament. Because the crime in that neighborhood, what do? They put police units out there. Let the good people in that neighborhood know that they're there to protect them. And a minute and a half later, he would have been there. What would have happened a minute and a half later? All these politicians, lawyers and whatnot would be sitting in this court. Because like other incidents in which that officer, Slager, got in trouble, the cavalry arrived. No one got hurt. He's put in a position out there as things are going downhill rapidly in seconds. And he's getting the tar beat out. And when he's on the phone, when he's on the radio calling for help, what happened? What you know what happened. You don't have to see them there. Because you know the difference in the use of the taser. You go back and check that. Check what I'm saying. And you'll see an unusual 24-second break. as opposed to the other tasers, before and in. What was happening? We're on the ground. He's calling for help. Check the time. See where that fits in that 24 seconds. And this, one hand's occupied, calling for help. Scott grabs Officer Slager's taser and pulls it away. Look at the pictures of Slager's hands. And you tell me whether or not they're consistent with getting something torn out of your hands. His right hand, the cut on his right hand, what they say is a nothing cut. I was bleeding 3 hours later. So what caused that? You know, he wasn't dialing on his cell phone. You know, by the way, the cell phone, there was a cell phone there, wasn't there? Remember they said he got out of his car, the cell phone was car, and run down the street with the cell phone. Well, we know he did. Because Slager heard somebody on that phone. And they were telling him to stop. And what the police said. So much so and so directive in saying that Slager thought that it must be the cop who was responding. Get on the ground and stop. Tell me about that phone. That phone is in Scott's hands. How did they get the yellow paint? How did the glass on that phone get split and cracked? Look at the picture. The state of South Carolina didn't come in and say, hey, you know, this phone's broken. And the state of South Carolina didn't come in and say, we matched the paint on Yellow Brick Road to the paint on the phone. No, they didn't do that. Slager did. Because he wants you to know the truth about what happened. So, the phone's also interesting in another way. Remember the GSR stuff? Gunshot residue. Where was it? It was found on Scott's right hand, right palm, left hand. Didn't find anything in the left palm. Why is that? Why is that? It's because this guy that was running away from being tased and shrieking, actually nobody heard him shriek. It's not on any tapes. He's not going out and pain on any of the tapes. But he had taken such a position over Slager in the ground fight. Think about this. The phone that was on the ground, he took the time to pick it up. How's that? Somebody who's running away from Slager. Why did she put in her notes that Slager was trying to get away from Scott when he had the taser? And she converted that into her report where it said Scott was trying to get away. I realize it's her first case, but you don't make those mistakes. You don't change that kind of information to give the impression that Scott's trying to get away when you were told Slager was trying to get away. So Slager's backing up. And this is one of the other video comes in. So I've lost track, but is this the fifth taser? Fourth taser? Let's go to the fifth taser. Seconds later, right? The consistency of the use of the taser is back on board. And what happens at this point? This is when we believe Scott, in that 24 seconds of possession. Okay, what happens now? What did the state tell you? They didn't tell you that they have evidence by the state law enforcement laboratory where there are markings on Slager's shirt that they didn't look at for 3 months ago as evidence of damage consistent with either a meteorite coming from close to Slager or him getting tased. Why does Slager have to tell you that? These are people that work for the state of South Carolina. These are people who work for the solicitor. These are people who are sitting in the back row. Look at them all back there. They're controlled by the solicitor, not by Mr. Slager. Yet they had evidence that Slager was tased. Didn't tell you. I guess they thought that you would think if it's not on the video, it didn't happen. So I'd be pretty outraged by that. When's the next stage? Again, look at the settings, the pattern of behavior used to that case. It changed. And this is Mr. Santana's video. Now, even Santana, who took this video, and he's not cop friendly, if you remember his little poetry he wrote 6 months before this incident, both Spanish and English, sang a song about it. Mr. Santana, who thought that it was not important to turn this video over, but to get it to his lawyers so they could sell it. Not exactly a patriot. Not exactly a guy who's interested in law and order. Not a guy who's interested in preserving the truth, whatever view that is. A guy who said that he panicked when he was stressful and resorted to Spanish, or the word I used in court yesterday, which I apologize for. He didn't have any problem using it under that stress, seeing somebody shot. Listen to the language he used, and then remember what he said from the witness stand. There's his lawyer. The lawyer that sold the video for $10,000 to somebody in Australia, a celebrity agent. You really not trust the police that much that you wouldn't immediately turn that over and say, hey, look what we got? What's the explanation for that? You can weigh that maybe he was confused, and as he said, he was scared, who knows? But you can weigh that, you can evaluate it. You know, if you have what you think is a videotape of a murder, I would suggest that most people would immediately go to some law enforcement agency. Immediately. Then we get back to the old narrative of the media about police shootings, you know, the racial overtones that were put on everybody. So Santana cranks up his cell phone video machine. Let's go through this image by image. And you, when you get back to the jury room, I know some of you have a computer account, please do this. So this taser, where it says on the top taser, is the last 4 seconds of the last taser. And so 4 seconds from now, 44, that taser thing will let it go out. Now we're moving at the rapid speed of 1/30 of a second. So stop right there. So when you get in the jury room, you can work with this Mr. Santana's video. And those of you that are sophisticated, you focus in on the images. You can't tell who's who. You can't tell facial recognitions. It's hard to even tell what that is. But you do know that Slager was wearing a dark blue uniform. And you do know that Scott was wearing a green t-shirt. So as you go through this, do it frame by frame. and see whether you can, fuzzy as it is, see if you can get a story out of this. Not with me guiding you through it, or Ms. Wilson guiding you through it, but you look through it. And see whether or not you can see images merging, and whether it's obvious that they're together, and whether it's obvious they go from standing to the ground, from the ground back up. So let's skip, if you can please, to one or two images. The jury will have all of them. Keep going. Whoa. Knowing what you know now, is there any question what that is? You can't see a face, but you know what that is. And you know who's on top. And you know what's going on. It's not a clear, perfect video, but you know what's going on. And you can look at another series of shots to tell what's going on. Now let's talk about, for a moment, how we're judging Slager. 18 months investigation, 5 weeks in the jury box, for seconds. Let's look at the last image of Mr. Scott and Mr. Slager standing up together. When you back to the jury, get a piece of paper. Nothing fancy. That took longer for that piece of paper to drop on the floor. You tried to get that. And the first shot to be fired after their hands all about fire. Ms. Wilson said it was 1.49 seconds. We thought it was 1.5. That's 18 months, 5 weeks, and that's what this case is about. They were in a ground fight after a 200-yard run. Hold up that equipment, see how much it weighs. Think about having a vest on that restricts you breathing, restricts your movement. A 1-minute fight that doesn't seem like much. Try it. Now, don't roll around the floor in front of the jury and act like that's a realistic representation of what went on that day. Let's take a couple more frames. When you get back there, you please do. Oh, by the way, stop for a second. When you get back there, take a look at where the feet are, the direction. You know, I'm not running this way when I have my feet pointing this way. And if I'm having my feet against the person I'm fighting with, I'm not running away. And oh, by the way, if I pick up my cell phone to run with, I'm not really running away at my first opportunity. But of course, it's not on the video, so we can't prove it. But you can get an idea of what's going on from the limited Santana video. Take out a couple of more frames. All right, stop, Rick. One frame early. Early. When you get back there, you'll be able to see that. There's a string, a white string, between Mr. Scott and Mr. Slager. When you get back to the jury room, follow that string. You know what that string is? It's the paper. And follow it frame by frame. As it stretches out, it becomes taut, and it's wrapped around Slager's arm. It's very hard to see here, but I assure you, if you look, you'll see. It's stretched between the two of them, it's wrapped around his arm, and goes down to his legs. How did that get there? If there wasn't a fight. And by the way, when you lose sight of Mr. Scott behind the tree, you see that white line there? You still see it. You still see it. You still see it. You still see it. It's getting caught. You still see it. And 2/3 of a second, first shot is fired. 2/3 of a second. Look at it when you get back. Don't take my picture. 18 months, 5 weeks. And we're talking about a second and a half. We're talking about 2/3 of a second. We sit here in armchairs, we sit here with photos, we sit here with a pot of coffee, put our arms up, put our feet up on the chair, and we make judgments. You've got to think about what's going on in those nanoseconds and what was in Mr. Slager's mind. Was it a brave heart? Was he full of evil? Did he have a commitment to wreak havoc, to kill somebody, murder somebody with malice? I warned you a month ago that the solicitor, even though they have a book this thick with charges, they charged him with murder. Look at the indictment. They didn't charge him with manslaughter. They don't know anything more today than they knew a month ago. But they think that if they give you manslaughter, and somebody you might say it's not murder, and somebody says, well, we would acquit him, that you compromise. They call that a compromise verdict. The judge referred to it as lesser included. Lesser included? What's the definition of that? A homicide. You don't get out of jail free on a homicide, whether it's manslaughter or whether it's murder. What did Slager know that? The act today is that Slager was all knowledgeable. You hear the media on what do they say? Unarmed. Right? Unarmed man. Shot in the back. Unarmed man. From traffic stop. Brake light. Unarmed man. Slager know that? Did he have a chance to frisk him? Did he have a chance to pat him down to see whether he was armed? Or would a reasonable person, untainted by the media, in the course of his public service and his duty in chasing this person, should he have assumed that an unarmed man would have attacked a police officer wearing that equipment? A man who attacked him and disarmed him of his taser, should he have assumed that he was unarmed? The media acts like everybody knew it. The only person that matters is Slager. Is it reasonable for somebody who's engaged in law enforcement, when somebody acts with such recklessness and evilness to have a reasonable assumption that the only reason somebody would do something is to be someplace they got something they're hot or poison. Now, if he knew he was unarmed, if he really knew he was unarmed, it'd be a different story. It would be a different story if he knew where the passenger was. It'd be a different story if he knew who was on the phone that Scott's giving directions to, who was able. It would be a heck of a different story if there was a brake light and Scott ran down Craig Street, and instead of yelling, taser, 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 stop, bang. He didn't do that. He didn't shoot him because of a brake light. He shot him in fear of his life and in fear of Habersham, who was coming to his rescue, and others in the neighborhood, because this man was out of control and would do anything to stop anyone at that time. Was he going to carjack somebody? Was he going to grab somebody off the street? How was Slager supposed to know that? Can you imagine? My friends in the media, can you imagine if he didn't stop Scott? And Scott grabbed somebody off the street, or went into the money man, or went into the other pawn shop there, and robbed, took guns. Can you imagine what would be going on today? So in the instant, in the nanoseconds, he makes a decision. And because of the video, he's become a poster boy for all the other events that transpired in 2014 and 2015. Well, we didn't get them. An example. Don't let that happen. Don't let that happen. You have the photograph of the two, whatever you call those make-believe people. Yes. Take this one back in here. Because the state tried to infer, not factually, but they try to throw out and infer that Slager kicked the table, knowing it was untrue. You tell me how that taser got there if Slager. That's the view from a different angle, Sam. Because you all know from life's experience that different angles of looking at things give you different perspectives. If you're way down the street, you look up and you can't tell depth as much as you can tell separation. And you know from your experience that cameras can give distorted images. And you know that a 2D image is not the same as a 3D image. They try to slide that past you. And you kick the taser. And the idea behind that is the state wanted you to believe that Slager knew that the taser was on the ground. Didn't wind up in grass, didn't wind up behind him. Why would they do that? Evidence of a fight, there isn't any. Oh, there's no fight. It wasn't a Donnybrook. It wasn't a fight. It was, what do we call it? Shuffle or a scuttle, or some other word. Would infer that really it wasn't any big deal. If there was no fight. How was Slager injured? How do you get those cuts? How do you get the dirt over his? How do you get the taser marks? How do you get the dirt under his shirt and reflect? How about Mr. Scott? How about his injuries? How about Dr. Tormos showing the photographs of injuries consistent with not one or two, several of them? How about the dirt and blood on Officer Slager's pants and his shirt? How about Mr. Scott's watch that was broken? The photographs. It wasn't a fight. And we talked about it so. But the most telling of all, in my mind, and modern science would help us on this, is the DNA. Now, a very inexperienced, but not a bad person, I say not confident, but that might be too strong. In case this serious, without guidance, took cotton swabs and went all over the taser. Slager didn't do that. We didn't do that. We didn't respond to that. But the state of South Carolina did that. Knowing that there was a dispute over possession and use of the taser, they had that knowledge, right? They knew that at the time they got the DNA. Go back and check your notes. They knew it at the time. The large fellow, I don't remember his name, Albert, I think, Brown, who was the senior crime scene guy, wrote his notes, get fingerprints and DNA. Why did he do that? Because he knew there was a dispute. And he knew that the taser would easily take fingerprints. And this thing about you can only do one trace evidence thing at a time, hot wash. You have to plan it out, and you can do several trace evidence examinations as long as the sequence of that doesn't destroy the follow-on evidence. And it's done all the time. But some captain who never showed his face made a decision not to get fingerprints in DNA. And he made that decision to get DNA, but they swabbed the whole taser. So that if you're arguing about who touched the object where, you lose the value of that DNA. So I think what the state said in their opening argument, you go back and look at the notes, but they said, of course there's DNA on it, because Slager crashed on it. Well, what's the only place on the taser that the SLED agent didn't take a DNA sample? Business end of the taser. They didn't take a separate sample from the barrel, if you will. They didn't take a separate sample from the trigger. But what we do know is that Mr. Scott and Mr. Slager both have their DNA on that taser. But if you don't want to believe something because you can't see it, if you're doubting Thomas, right? And you didn't see it on the video, therefore you don't want to believe it. That's a pretty simple explanation. Slager type tased in, and that's what the DNA is on. It's contradictory to all of this. That's the same thing that there was in the fight. It's contradictory from morning to noon till night. It was a serious fight after a 200-yard run. You all have heard for 5 weeks the facts of this case, and I just want to point out a couple of areas that I think would be beneficial to make the determination. But remember all your deliberations, an important part of the rule of law is the presumption of innocence. And you'll hear the judge talk about this. Cardinal rule of law. At this moment, during Solicitor Wilson's argument, until you get in the jury room, after you're in the jury room, until the 12th of June, God forbid, find him guilty of one of these charges. He's presumed innocent. Nobody can take that cloak of innocence off his shoulders. That's a principle in the United States criminal justice system. Presumed innocent. In this case, I believe there's actual innocence. And we talked about that a couple of weeks ago. Innocence doesn't mean in the law what it means at home. Not guilty is a different concept than innocent. Not guilty means that you did not engage in criminal behavior. You may be held liable civilly for your actions. As I said earlier, this is the most serious charge that anyone living in South Carolina or the United States faces. Murder. That's what the state has elected to charge. Go across the street, die of murder, moral or manly, charged with the same thing. That's how serious this is. And that's the weight you have when you judge manslaughter. Murder, manslaughter. You know what manslaughter is? Manslaughter is when you go home and you catch your wife in bed with your best friend. That's manslaughter. That's when you're provoked by the actions of your loved one. That's what heat of passion is. This is not heat of passion. This is a law enforcement officer carrying out his duties who was provoked. Yes, he was. Got punched in the nose or wherever he got punched, got dazed. That's provocation. But provocation is meaningless in this circumstance unless you see evidence of him going, what's the word? Lose rational reasoning temporarily. He's so upset, he's so overcome by what happened that he loses his sense of responsibility. Angry as you imagine your own spouses. That kind of thing. Right? Didn't take place. Manslaughter is a red herring. You came into court 5 weeks ago, there was no manslaughter. It's that as the case started to erode, when you heard about all the evidence that preceded the shooting, and you didn't just be confined to the shooting itself, the state started backing up. And they came up with this concept, well, maybe it's not murder, maybe it's manslaughter. This is not a deck of cards. You just don't hand out cards and let people figure out which one they're going to play. This is not a card game. It's the most serious matter that one can be charged with. So you got the presumption of innocence, evidence beyond reasonable doubt. You have a reasonable doubt. You don't know what that is from your life's experience. It's not a legal principle. It is a legal principle, but it's got everyday application. You go in, you look for a house, you look over in the house, nah, I want this one. We're in the most important matters in your life. Choose a wife, choose a husband, right? Don't think I want to spend a life with that person. Serious matter. You have to be convinced of what some call a moral service. Here this is the judge uses. You have to have a rock solid commitment that each and every one, either offense, is meant. We're talking about self-defense now. The judge is going to charge you with self-defense. I'm not in his position because I'm not sure what self-defense is. Policemen, police don't operate on the same thing that you and I. Right? Their job is to go out and enforce the law. So Do you really want a policeman to be in a situation like this and run away? Sort of what Solicitor indicated that they would do. Now, when you're out enforcing the law and somebody acts so violently that you commit 4 felonies, resisting arrest, taking a taser from the police officer, assault and battery, and robbery, you just don't let it go. And reasonableness is when you say, I've had enough, hands up, I surrender. Reasonableness is when somebody's attacking you and they can disarm you, and it takes you 1.49 seconds or 2/3 of a second to use what's never going to be used by a police officer. Do you think this makes him feel good? They can life to somebody. Those of you that have friends in the military, do you think anybody comes home? I agree, no. Sticks with you for the rest of your life, just like it will affect the Scotland for the rest of your life. It will affect life. So, last thing I got to say. When police officers in South Carolina, the city of Charleston, North Charleston, Anaheim, Goose Creek, Olive Creek, Mount Pleasant, Somerville, Orangeburg, Columbia, blah, 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 on and on. Go to work every day and patrol the streets. That's what they do. Their greatest protection is the support of their community as they go about it. And to charge a police officer under these circumstances with the most serious criminal offense undermines not just Michael Slager's career over, but it's a message to every man and woman. Wear the badge. That is in the heat of battle. The decision you make at most in a second and a half, and then 2/3 of a second. We're going to prosecute you for murder as you go back to jail. As your fellow citizens, forget about being a lawyer. As your fellow citizens, I ask that you not do that. And you have the courage and your convictions based on your understanding of the evidence in this case, the testimony you've heard, that you find Michael Slager not guilty. Murder? Not guilty. Yes.
Ladies and gentlemen, it'll take about 10 minutes. Please go to the jury room. Please do not discuss the case. Is 10 minutes enough time?
I probably need a little bit more, because I got information or two, but I'll hurry.
All right, we're estimating.